Hello and welcome to the Minimum Competence episode for Monday, March 9th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, publishers suing a massive shadow library, California's climate disclosure laws in court limbo, a social media addiction trial, and $166 billion in tariff refunds. Let's remember, Monday is for people with a mission, and read today's legal news. On this day in legal history, March 9th, 1841, the U.S. Supreme Court decided United States v. the Amistad, ruling that a group of Africans who had seized control of the Spanish ship La Amistad were free individuals who had been illegally enslaved. The case began after the captives, led by Sengbe Pieh, often called Cinqué, revolted against the ship's crew while being transported from Cuba in 1839. They had originally been kidnapped in West Africa and sold into slavery in violation of international agreements banning the transatlantic slave trade. After the revolt, the ship was intercepted near Long Island and the Africans were taken into U.S. custody. Spanish officials demanded that the United States return both the ship and the captives to Cuba. The U.S. government supported Spain's request, arguing that the captives were property under Spanish law. Abolitionists rallied to the Africans' defense and secured legal representation for them in American courts. The case eventually reached the Supreme Court, where former President John Quincy Adams joined the legal team arguing for the captives' freedom. Adams delivered a lengthy and passionate argument emphasizing natural rights and the illegality of the slave trade that had brought the Africans to Cuba. Writing for the majority, Justice Joseph Story concluded that the captives had been unlawfully enslaved and were therefore not property. Because they were free individuals, the court held that they had the legal right to resist their captivity and fight for their liberty. The court ordered that the Africans be released rather than returned to Spanish authorities. The ruling was celebrated by abolitionists as an important moral and legal victory in the fight against slavery. Although it did not end slavery in the United States, the decision demonstrated that courts could recognize limits on the slave trade and acknowledge the legal claims of enslaved people. 13 major U.S. book publishers have filed a copyright lawsuit against Anna's Archive, a website they describe as one of the largest shadow libraries distributing pirated books and academic papers. The publishers, including HarperCollins, Wiley, McGraw-Hill, and Cengage, filed the complaint in federal court in New York, alleging that the site hosts more than 63 million books and 95 million research papers without authorization. According to the lawsuit, Anna's Archive allows users to download these materials directly or through torrent networks, making copyrighted works widely available for free. The publishers claim the site openly presents itself as a pirate platform and intentionally violates copyright law. The complaint also alleges that Anna's Archive was created in 2022 after copying entire collections from other illegal book repositories and has continued expanding its database. The publishers say the site operates anonymously and frequently changes domain names across different countries to avoid enforcement efforts. They further claim the platform targets artificial intelligence developers by offering large data sets of books and papers. While free users can access files slowly, the complaint states that faster downloads are available to users who make donations through untraceable methods like cryptocurrency or gift cards. The publishers allege these donations can reach roughly $200,000 for high-speed bulk access. In response, the plaintiffs are asking the court to shut down the site and award statutory damages of up to $150,000 for each infringed work. The lawsuit follows a separate case brought by Atlantic Recording Corp., which earlier obtained a preliminary injunction preventing Anna's Archive from distributing millions of music files allegedly copied from Spotify. That case resulted in a default after the site failed to respond to the complaint. However, the publishers argue that the earlier injunction does not cover books, allowing the alleged book piracy to continue. The Association of American Publishers has publicly supported the lawsuit, describing the scale of digital piracy as extremely large and urging legal action to stop the operation. Companies that operate in California are facing uncertainty as the state moves forward with major climate disclosure laws, while a federal appeals court considers whether the rules should be blocked. The laws, California Senate Bills 253 and 261, require large companies doing business in the state to disclose information about greenhouse gas emissions and climate-related financial risks. In late February, the California Air Resources Board, or CARB, approved initial regulations explaining how the reporting system will be administered and how companies will pay implementation fees. At the same time, the Ninth Circuit has temporarily blocked enforcement of FB 261 and is reviewing a request from business groups to halt both laws entirely. Because of this parallel regulatory and legal process, many companies are unsure whether they should invest heavily in compliance or wait for the courts to rule. SB 253 applies to companies with more than $1 billion in annual revenue and requires reporting of Scope 1, Scope 2, and Scope 3 greenhouse gas emissions, which include direct emissions, energy-related emissions, and emissions from supply chains. SB 261 applies to companies with more than $500 million in revenue and requires disclosure of climate-related financial risks and mitigation strategies. Attorneys say collecting this data could be difficult, especially for companies that only have limited operations in California or that must gather information from suppliers and partners in other regions. The reporting requirements could also affect businesses outside California because companies subject to the law may need emissions data from their partners and vendors. Regulators have begun setting deadlines for initial reporting, including an August deadline for certain emissions data, but many details about how the system will actually function remain unresolved. Meanwhile, business groups, including the U.S. Chamber of Commerce, argue the laws violate the First Amendment by forcing companies to speak on controversial issues related to climate change. With rulemaking still underway and litigation ongoing, companies are left trying to prepare for possible compliance while waiting to see whether the courts ultimately uphold or invalidate the laws. In a major California bellwether trial over claims that social media harms children's mental health, the plaintiff has finished presenting her case against Instagram and YouTube. The plaintiff, a 20-year-old referred to as Kaylee GM to protect her identity, alleges that features on the platforms contributed to anxiety, depression, and body dysmorphia she experienced as a minor. Her attorney, Mark Lanier, chose not to call Kaylee's mother to testify live, instead presenting a brief portion of her deposition to the jury. The decision appeared partly influenced by strict time limits imposed by the judge during the trial. In the deposition testimony, the mother acknowledged she had little knowledge of her daughter's social media use and did not monitor her phone because she viewed it similarly to a household landline. Defense attorneys have argued that Kaylee's mental health problems were caused by difficulties at home rather than the platforms themselves. Evidence introduced at trial suggested the plaintiff had conflicts with her mother, including allegations of neglect, verbal abuse, and limited supervision of internet use. The defense also pointed to bullying and other personal issues as alternative explanations for the plaintiff's struggles. Meanwhile, a former Meta employee testified that internal company information suggested Instagram could be addictive and harmful to young users, although defense lawyers challenged his credibility and the extent of his involvement with safety issues. The plaintiff's final expert witness discussed ways social media companies could design safer platforms for children. After the plaintiff rested, Meta began presenting its defense with testimony from school administrators connected to the plaintiff. The case is the first bellwether trial among thousands of similar lawsuits consolidated in California, with outcomes potentially shaping settlement negotiations and future trials. TikTok and Snap previously settled with this plaintiff, but the broader litigation against social media companies continues. The U.S. Customs and Border Protection, or CBP, agency told a federal trade court that it expects to create a system within about 45 days to process refunds for tariffs that were previously imposed under President Donald Trump and later ruled unconstitutional by the U.S. Supreme Court. The tariffs generated roughly $166 billion in payments from about 330,000 importers. But remember, tariffs are paid by consumers, and the court's decision did not specify how those funds should be returned or who they should be returned to. As a result, government lawyers and a judge from the U.S. Court of International Trade are working to establish a practical process for issuing refunds. Under the proposed plan, importers would submit a declaration through CBP's electronic system detailing the tariffs they paid. The agency would verify the information and then issue a single payment from the Treasury Department to each importer, including interest. Officials say this approach would avoid forcing businesses to file individual lawsuits to recover their money. The judge overseeing the matter recently modified an earlier order that required immediate refunds, acknowledging that the agency needs time to build a workable system. CBP explained that its current administrative system cannot automatically process refunds on the massive scale required. Importers paid tariffs on more than 53 million shipments, and manually reviewing each transaction could require millions of hours of labor. Several large companies, including affiliates of Nintendo and CVS, have already filed lawsuits seeking repayment, though the government hopes a broader refund system will resolve claims more efficiently. Business groups such as the U.S. Chamber of Commerce have supported the proposal, saying it could simplify the process for smaller companies. However, officials note that relatively few importers have registered for the electronic refund system created earlier this year. The court continues to oversee the development of the refund process through a test case that could guide how payments are returned to all affected businesses. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here on Monday, and until then, remember, either you run the day or the day runs you.